Chris, let's go back, and we've had some questions because you're now going to talk about introduction and use of trial exhibits. And there's been some interest in your iPads. And one of the questions is, gee whiz, how do you put a stamp, and how does the clerk, put an admitted stamp on an iPad? Um, I assume you'll explain how that works.
Yeah, this is where you'd want to be calling the court clerk beforehand and figuring out if they're open to this idea of having electronic exhibits. In that case that we did together, Garrett, the clerk was great and she loved it. It was actually easier for her. We didn't have um, really any issue at all with it. Some clerks will want the paper copy delivered to them, and so they can put their stamp on it and they're going to hold it for the court. Other clerks will say, hey, we'll just identify it and it'll be in the minute order, and you or the other attorney will maintain custody of that exhibit and use it, bring it to the court when needed. So it's really all over the place. But I many times do find myself printing a copy, at least for the judge. Some judges are definitely paper based. They prefer to take notes on the exhibits. And so I want to provide it in the way that they feel comfortable. And so I've done it all these different ways. I've had judges who said, hey, I want everything in paper. And then they see the mountain of paperwork behind them and all the binders trying to juggle on their bench. And by the end of the trial, they're using the iPad. So
Well, how do you,
case by case.
but record on appeal, you can't send the Court of Appeal an iPad. So I assume that most courts are going to want at least a paper copy, even if the judge is looking at it on her iPad or your iPad. I assume that the clerk is going to want a paper copy, to maintain at least until the time for appeal runs.
Well, I mean, what I've been seeing is the many times the trial court is telling counsel to hold on to the exhibits until the time to appeal is ended, and there's an order issued for that, and the exhibits are returned. If it's done that way and there's an appeal and designation of record and somebody designates the exhibit to be part of the appellate record, then we would transmit that to the court clerk, and the court clerk would put that in the clerk's transcript. And so I just went through that process now with appellate counsel on the other side, and we agreed on, hey, these are the exhibits. So it can be done. I think we're going to see hopefully more of a process rather than an ad hoc as more people get away from managing their stuff on paper, because it is sure easier to do so. And with trial courts doing more electronic filing, again, and I'm doing it this way with RFOs, and we may have this gigantic RFO that's several hundred pages long. I'm going to sequentially paginate that so I can tell the court, hey, go to page 123, because they're looking at it on their screen now, not on paper. I'm doing an appendix of exhibits to support the RFO and citing to that, just like I would do on appeal. So as we get away from paper, we'll see more of this. Now, and that's a good segue in talking about exhibits. And this is an area of weakness for many of us, because we know we have this document. It's super important. We know we want to get it into evidence, but there's a dance. There's some steps that need to be taken to get this thing in. And unless we're doing it all the time, we either don't know how to do it or it gets a little bit rusty. So I'm going to walk through this in some detail. Now, one thing to remember is that even though you have your exhibits that are all marked and they're there, they're submitted, they're on the exhibit list, does not mean that they're in evidence. Matter of fact, they're not in evidence until the court says that they are. Same with declarations that you would file in a motion or RFO. Those are not in evidence unless you move them into evidence. So just because the court is aware of it or you've talked about it doesn't mean that it's in evidence. So there's a distinction between talking about a document in court and actually getting it in the record. So talking about it, we could do for all kinds of reasons. We could be maybe discussing whether it will go into evidence, or maybe we're using it to refresh recollection and we're never putting it into evidence, or maybe it's a demonstrative exhibit like a chart or some summary of other testimony and we're not intending it to get in. So there's all kinds of reasons why we would talk about something. We got to make sure, though, that it is in evidence if we want it to be. And many times that trade can be done before trial starts. Hey, let mine in and I'll let yours in, and maybe we fight over 2 or 3. That's easier done at the beginning. After the trial, they now know the impact of that exhibit and they may not be willing to agree to it because they know that it's stung. So I would try and get the agreements up front. Now, we've already marked our exhibit. We've talked about that in the little other session. So we already have the thing. We have it marked as Exhibit 1. Now, how do we use it in court? What is the dance? Well, it's super easy. The first step is we identify it. And the reason to identify it, number one, is so everyone can get on the same page. Literally, the judge and opposing counsel, the witness who's on the stand can actually see this document. They know what you're talking about. Secondly, for the record, the court reporter is taking down the words that we say, not the images that we see. And so this is where a lot of us go wrong. I'm showing you this document. You see right here at the bottom or right over here. No, that's not a record. The witness may understand, the judge may understand because they're watching you do that. But when we get the transcript later, it's not going to work for us. Say we're trying to impeach that witness later on in some other hearing or another day of testimony. We don't know even what they were looking at. So I'm very particular, and I would slow this process down. Witness, I am showing you a document marked as Exhibit 1. Do you have that? Yes, I do. And then whenever you're talking about it again, okay, please, Exhibit 1, go to page 22. Everyone knows it's very clear and the record is there. Now, how do we actually get this thing into evidence? I'm not a big fan of mnemonics, but the one that I like is RASH. And this thing saves me all the time. RASH, relevance, authentication, secondary evidence, and hearsay. So that's relevance, authentication, secondary evidence, and hearsay. If you cover all those, you're going to get the thing in. There are some policy limitations on evidence, which could mean like the mediation confidentiality doctrine or privilege. You don't see those as much. And I guess we could throw a P in there, a parash or something like that. But most of the time it's rash. So relevance is, does this document or testimony tend to prove or disprove a fact in the case? Okay. Pretty much basic. We know it when we see it. Authentication is where it's a little bit more tricky for folks. And I do want to back up a little bit here actually on foundation. Sometimes you'll hear attorneys objection, no foundation. Well, technically that's not an objection. There's nowhere in the evidence code that says that evidence will be excluded unless a foundation is laid. Well, foundation is really referring to this bigger concept of evidence has to be relevant to be admissible, and it has to be authentic enough or genuine enough for us to trust it to be going into evidence. And so that's the foundation for it. Is this relevant? Is it authentic or trustworthy enough? So that's slang. So you don't want to object based on foundation. You want to object based on relevance. You want to object based on it's not authenticated. You want to object based on secondary evidence, very weak if that ever comes up, or you want to object on hearsay or privilege or other policy limitations of evidence. So what does authentication mean? The A part that messes a lot of people up. Well, it's easy. It's just enough proof to show that the document is what you claim it to be. It's not absolute proof that it is It's just enough proof that it is. So for example, maybe we're litigating over a premarital agreement, and there's a question over whether this is the agreement that they signed. Maybe there's several versions floating around of this thing, and you have your client on the stand. I'm showing you a document marked as Exhibit 1. Okay, so now we've identified it for the record. What is this document? If you ask that question, so right after you ID it, second question, what is this? That question is going to lead to authentication almost always. What is this document? Answer, this is my premarital agreement. Wow, okay, so they just identified the document, they've taken ownership of it, they said it's theirs. You can ask a further question, well, why do you say that? Well, because I signed it. How do you know that this is the version that was signed? Well, I remember signing it. I can see right here. I initialed every page. So we're telling a story. We're authenticating it, meaning that we're providing sufficient proof to show that this document is the agreement that we claim it to be. It doesn't have to be absolute. We know it's a disputed fact. It's good enough. We can get authentication through testimony, like I just demonstrated. We can do it through stipulation, like in that meet and confer process. We can also do it through admissions and presumptions. And I encourage you to read the evidence code. I love the evidence code. Whoever wrote that 150 years ago is a genius, because it actually makes a lot of sense and it's well organized. And a lot of the code sections are like one sentence long. Modern statutory language, horrible for the most part, really long, lots of exceptions. For some reason, they knew how to write back then, maybe because they had to type it or write it by hand, and they were more conservative with the amount of words that were being used. So the go through that, and we're going to talk a few about what evidence code provisions will help you authenticate a document when the other side won't agree. So I have a slide here, I think it's 117, where we're going through, a little litany of some questions that you might ask. Again, I've identified the document. What is this? That should always be your go-to question. That's going to almost always authenticate it. But now this isn't important. This is the prenup. We're trying to prove this is the agreement that's going to save our client from having to pay half of everything that was earned during the marriage. So sit on that, start asking the questions. Did you prepare this document, or did your attorney prepare this document? Did you sign it? Do you recognize the signature here next to yours? How do you recognize that? Why do you think it's your spouse's? How did you come in possession of this document? And here's the key. Did you alter it? Has any change been made to this document? So if you ask those questions, that's bulletproof. That's coming into evidence. That's authenticated. That is established enough to show that it is what we say it is. Again, the other side might say, oh, but we think there's a second version floating around. Fine, they can authenticate that one, but I just got mine in. That's enough. Now, what if the other side is contesting it, and we want to get this thing in and we need a little bit more? Well, evidence code 1414, around there, there's about 5 sections there that help us with this. Now, one of them is an adverse party admitted to the authenticity or acted upon it as being authentic. So admitted to authenticity, that could mean providing it in discovery responses. So you did your discovery, they produced it. I would say, well, maybe that's an admission of authenticity. I mean, I got it from them. If they've acted on it as authentic, they've showed it around, they provided this document to other people as if it were authentic. So you can use the evidence code. The writing was in response to communication sent to the person claiming to be the author. So we have this two-way communication. Well, hey, I have my response. Well, their letter that I'm responding to is now maybe authenticated through 1420 of the evidence code. Here's one: refers to matters unlikely to be known by anybody else other than the author. That's 1421. So if there's some message that was sent, an email that was sent that has information that is unlikely to be known by anyone other than purported author, you could say this thing is essentially self-authenticating. Who else would have known this information to write this email? Again, you don't have to prove it to a certainty. You just have to prove that it's more likely than not the authentic. And then if there's a subscribing witness, like a notary or a witness to a will, 1411 says that comes in, that's authenticated. That's enough. Obviously, you have hearsay issues. We're just now talking about, is the document what you claim it to be? Moving them into evidence now. So we've identified it, we authenticate it. Now the last part of the dance is, and now, Your Honor, I am moving Exhibit 1 into evidence. Do it while you have the witness on the stand, because if there is an objection regarding lack of authentication, hearsay, whatever else, and sustained, you want to fix that while you have that witness on the stand and not wait till day 7 of the trial to do it. And then final point is that if you're on the other side of this and you don't want it in, throw out the objection. You don't know. A lot of judges might agree, just say, yeah, I think that's hearsay, or it's not authenticated. Sustained, keep it out. So don't be afraid to object. Garrett?
One thing I would just add, Chris, and that is when you offer it into evidence and it's not accepted, be sure to make an offer of proof as to the relevance of it, the significance, why it's being offered, because one of the cardinal rules is you can't appeal the exclusion of evidence unless you have made an offer of proof to the court as to why it would be admitted and why it's important. Anyway, that was great. Thank you.